On August 10, 2026, Silicon Valley suffered a major legal setback as a federal appeals court refused to halt a wave of youth safety lawsuits. The lawsuits accuse major platforms of designing products that keep young users compulsively engaged, with consequences that may reach far beyond one courtroom. More than 3,000 claims are now moving forward. The litigation is not a final verdict, but the legal barrier has been lowered. The companies deny wrongdoing, and years of legal battles may still lie ahead, yet the central question has become impossible to ignore. Can an industry built on maximizing attention survive when the systems that drive attention become the subject of legal scrutiny? For years, the social media economy ran on one ruthlessly simple calculation: more attention means more time on screen, and more time means more ads. More advertising inventory means more revenue. Plaintiffs say that calculation did not merely shape the business, it shaped the product itself. The alleged tools are familiar: an endless feed, notifications that pull users back, and autoplay that removes a moment of choice. Recommendation systems continually search for the next compelling piece of content, reducing friction between a user and another minute of attention. This is the attention engine, a series of tiny, nearly invisible design choices that can keep a person inside the product longer. The legal argument is not simply about a harmful post, it is about whether platform design itself encouraged compulsive use. Plaintiffs argue that young people were especially exposed and that companies understood potential risks while optimizing engagement features. That distinction moves the dispute toward the systems companies built, measured, tested, and refined. Platforms have long relied on Section 230 as a powerful legal defense. It is not gone, and this ruling did not decide every claim. Instead, the appellate court denied an early escape route. The evidence and alleged harms can now be examined more deeply. One complaint becomes many. Families, young users, school districts, and state attorneys general form a widening legal front. Coordinated litigation moves claims through complaints, discovery, motions, trials, appeals, and potential settlements. The process can be slow, but economic pressure can arrive early as legal fees, disclosure demands, and investor concern accumulate. Discovery is the hinge point. Lawyers seek documents, research, design records, communications, and internal assessments. In New Mexico, reporting described a $375 million jury verdict and a $567 million abatement fund, about $942 million in combined exposure. One state case does not decide every other case, but it can create a playbook for plaintiffs, regulators, investors, and corporate risk managers. The $100 billion headline needs precision. No court has set a $100 billion verdict. It is a measure of possible systemic exposure. Thousands of claims, jurisdictions, settlements, damages, compliance costs, and legal fees can create risk far beyond any single case. The deeper threat is not only what companies might pay, it is what they may have to change inside the engagement engine itself. A notification appears, a user returns, a video autoplays, another recommendation arrives. Each step can create another ad opportunity. The engagement graph is illustrative, not a measure of any company's actual user activity, but it captures the economic logic under scrutiny. At the compliance moment, a legal red marker lands on the graph. A soft glow becomes one continuous scan wave across the interface. Notification limits slow prompts, autoplay restrictions restore a pause, recommendation controls reduce the next suggestion. A chronological feed option reorders the experience. The graph does not crash, it flattens, suggesting potential pressure rather than a proven outcome. If platforms redesign features that maximize attention, can they preserve advertising efficiency? The answer remains unresolved. Compliance can change the design, the business impact remains unresolved, and that uncertainty is now part of the legal story. User safety appears on one side of the scale, engagement revenue appears on the other, with no simple answer between them. Social media is not disappearing, the infinite scroll is not dead, but its role as an unquestioned objective is being challenged. The court cases do not decide the outcome today, they create pressure, force disclosure, and open a wider debate about design. For big tech, the central issue is whether attention can remain the product's primary objective. This is the corporate ricochet, a legal battle that may reshape how the internet measures growth, risk, and responsibility. The legal reckoning has begun, and the next decision may shape the future of the attention economy.